Now invite counsel and Mr. Wiske, please come forward in 127056 in the matter of Jason Wiske.
Madam Chief Justice, may it please the court. Alice Walker, Deputy Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator, I have requested 3 minutes for rebuttal. This is an original proceeding in attorney discipline involving the respondent, Jason P. Wiske, who has been licensed to practice law in the state of Kansas since 1997. This matter comes before this court pursuant to Rule 223 under a summary submission agreement. The parties have jointly stipulated to the factual findings, the rule violations, the aggravating and mitigating circumstances applicable in this case, and are jointly asking this court to impose discipline as a 90-day suspension, but that suspension be stayed for a period of 12 months of probation to comply with the probation plan that is outlined in the summary submission agreement. Now, I want to briefly touch on the facts that brought this case before the disciplinary administrator. It arose out of the respondent's representation of individuals following the termination of their parental rights in child need of care cases. The first case that came to the attention of the disciplinary administrator was the respondent's representation of an individual with the initials DT. In that case, the respondent filed a notice of appeal in, I believe, January of 2021 and took no further action on the case. In November of 2021, the state moved to dismiss the appeal for lack of the respondent filing a docketing statement. That motion was granted, and the appeal was dismissed. The respondent then filed a motion to a motion to reinstate the appeal, in which he indicated he had heard that filing deadlines had been suspended due to the COVID-19 pandemic, and he was also suffering from his own health issues that resulted in him not being able to perfect the appeal. That motion was granted and a filing deadline was given. The respondent did not file a brief at that deadline and a suspense order was issued. Again, the respondent failed to file a brief and DT's appeal was dismissed. That occurred in May of 2022 and the case was referred to our office. It was docketed and the respondent was notified of that complaint. He submitted his attorney response in which he immediately took accountability for his actions, recognized his misconduct, and even alerted the disciplinary administrator's office to 2 other cases that were following a similar pattern. The first case he identified in his attorney response was his representation of an individual named AH, and that case followed almost the exact same pattern as DT's case. He filed the notice of appeal in, I think, February of 2022, did nothing further on the case. That was February of 2021. February of 2022, the state again filed a motion to dismiss, and that was granted, where the respondent was again faced with filing a motion to reinstate the appeal. He cited the exact same reasons as what he cited in DT, and that motion was granted. That case, he received the order with the filing deadline for the brief, I think was going to be in July of 2022. That was pending at the same time as the disciplinary investigation. And just a few days before that first briefing deadline, he actually met with the disciplinary investigator, indicated that he had, which he had also indicated in his attorney response, he was seeking to withdraw from all of his child need of care cases. He had indicated to Crawford County he was stepping back from that juvenile contract because he believed it was in the best interest of his clients. He also did not believe that he could continue in that role. He, however, told the disciplinary investigator that if he did not withdraw from that case, he would be able to complete the appeal. He did miss that initial briefing deadline in July of 2022, but when the suspense order came out, he did meet the deadline in August of 2022, saving AH's appeal. That matter was heard by the Court of Appeals, and the Court of Appeals affirmed the district court's ruling. The third case that our office was aware of that came to our attention through Mr. Wiske's attorney response was his representation of an individual with the initials AF. That case was slightly different than the other 2 cases. AF's case, he filed a notice of appeal, I think it was in March of 2022. And although under the Child Need of Care Code, it's required to be verified, he inadvertently or due to a clerical error filed an unverified notice of appeal. That actually was not what was fatal of that appeal at that time, although it could have been on its face. What ultimately occurred in that case is that a docketing statement, a verified docketing statement, was again not filed. There is evidence in our record through the respondent's exhibits, they're in Exhibit H, or his Exhibits H, some email communication that he attempted with his client. We have that in March of 2022 after he filed AF's, I'm sorry, I think I said AH, I meant AF is the third case. He had some email communication following that notice of appeal with AF in which he said, I need this verified docketing statement. There's an email where he gets a response which appears to be from a family member that says AF is in custody on a failure to appear warrant. And then the next documented attempt we have from the respondent to get that verified docketing statement comes, I believe, on May 30th of 2022, when he indicates to his client, I need this by Friday to save this appeal. He does not get that docketing statement, and at the same time, the state files a motion to dismiss in AF's case, which is granted. In June, the respondent is moving, June of 2022, he's moving to withdraw from all of his child need of care cases. He's notifying the court that he cannot continue under that contract, but he is making some additional attempts with AF. There are a few emails saying, I need this docketing statement back. And he does not get that docketing statement back prior to his withdrawal on July 1st of 2022. Now, the parties have also jointly stipulated that this misconduct violated several rules of professional conduct. In regard to DT, the parties have stipulated that the conduct violated KRPC 1.1 competence, 1.3 diligence, 3.2 expediting litigation, and 8.4D conduct prejudicial to the administration of justice. In regard to AH, the case in which the respondent ultimately got that brief unfiled and saved AH's appeal, the parties stipulated the conduct violated 3.2 expediting litigation. And in AF's case, the parties stipulated that the respondent's conduct violated 1.1 competence, 1.3 diligence, and 3.2 expediting litigation. The parties have also entered into an agreement regarding the aggravating and mitigating factors in this case. The aggravating factors being that the respondent does have prior attorney discipline, being a diversion through our office, that the facts of this case show a pattern of misconduct with similar behavior in each of these three child need of care appeals, that he violated multiple offenses, and that he has substantial experience in the practice of law. The mitigating factors or circumstances appropriate in this case are that there is a lack of or an absence of dishonest or selfish motive. There's also significant information in the record that the respondent was suffering from personal or emotional problems that contributed to this misconduct. The respondent acknowledged that in his initial attorney response, and he took that remedial measure to step back from that child need of care contract for the best interests of his clients, to protect the public, and to make sure that he was not experiencing any more overwhelming or stressful caseload. He also had been suffering from depression and bipolar disorder. He also suffers from diabetes he was not properly managing. He had COVID-like symptoms in the beginning of January and February 2022 that he did not test positive for, but was still suffering from those symptoms. And he also reported twisting his knee in March of 2022 that resulted in medication and time off work that all contributed to his inability and lack of competence in getting these appeals on file for his clients. The respondent has also shown a present and past attitude of cooperation through the disciplinary process. He immediately acknowledged his misconduct, alerted the disciplinary administrator to other cases that were following that same pattern. He also, in his answer to the formal complaint, admitted to the misconduct. He has also entered into the summary submission agreement, acknowledging the misconduct, stipulating to facts, aggravating circumstances and mitigating circumstances. He has also shown his good character and reputation in the community, as well as genuine remorse. The respondent also, through the summary submission process, submitted a probation plan to our office that he worked with myself and his counsel in detailing to ensure that it complies with Rule 227. The respondent's probation plan, which it's in volume 1, page 70 of the record. If you're looking at the summary submission agreement, it's page 12 of that agreement.
And let me ask about that. I'm not that familiar with it, so I'm asking this as a real question. Uh, on, I guess, volume 174, which is page 16 of the summary agreement. When we get to, let's see, that's 19, paragraph 19,
Okay.
where the respondent is going to sign releases for his doctors, and I think this also goes into paragraph 20, so that his supervising attorney and the disciplinary administrator's office can look at all his health issues anytime. Is that normal part of probation to have to give up all that privacy right? That's pretty significant.
In probation plans that I have had,
Yeah.
where there have been mental health or physical health, we have asked for releases to be able to speak with the physician or the psychologist. I don't handle the actual, once they're on probation, that goes to another attorney in our office, but I don't know of any situations where we're just requesting those documents. I will say that these terms were specifically submitted by the respondent and his counsel. And I don't, I can see, Justice Sandridge, the concern there. What I can state is that the purpose of that would be to see if there's anything that is going on that we need to be aware of. Typically, when we have an individual on probation, we look at the reports that are coming in, not only from the respondent, but from their practice supervisor that would alert us to, hey, there's something going out. The disciplinary administrator's office is not, as a general practice, going out and just requesting everybody's records and looking through them to see what's going on. We do rely on the respondent and their practice supervisor to take care of that probation plan and make sure they're in compliance. And then if there were to be something, we may call up that physician and say, what's going on? What do we need to be aware of? Is there something we need to know? It also then authorizes them to send in letters to our office saying, hey, the respondent is in compliance. They're doing what they are supposed to be doing. They're complying with treatment. I know that it's redacted, but I believe in the affidavit that the respondent provided.
Everything's redacted in it.
Yes, I think that on those are redacted, at least for the court, for filing purposes. It's my understanding, and all that.
I think it's totally appropriate that it's redacted,
Yes.
because what you have is you have underlying issues, like if you're talking to a therapist or you're talking to your DO about specific medications that you're going to take or medication management, that's one thing. And then you have the symptoms of, whatever kind of mental health concerns that you have. And that's what shows up. And so I can see reporting, that you could get a report about what symptoms. Okay, but when you're talking about full releases about what did he discuss with you, that's pretty, a huge invasion of privacy. But if he's the one that submitted it to you, I just wondered whether that's normal. I've only been on the court 3 years, but I've never seen that in a probation plan or a summary submission.
And I'd have to go back to look at each specific probation plan to say this is the normal language we use, or if as I'm standing here, my best recollection of ones that I've done in the past have indicated that we can speak with the physician or the psychologist, whichever professional that it is, and get reports from them. And typically the letter that we get will say, this individual is under my care. They have been following, the care plan or whatever it is. Of course, if this court has concerns with the terms of this probation and chooses that probation is the appropriate discipline, could always indicate modifications to those rules in its final order if that is a current concern in this specific case.
Thank you.
With that, I will note I am out of time. If I may just briefly conclude. I would just ask that this court adopt the summary submission agreement, the findings of facts, the rule violations, the aggravating and mitigating circumstances as outlined, and impose a discipline of a 90-day suspension, but stay that suspension for the 12-month period of probation, consistent with the terms of probation that we have outlined or as modified as the court sees fit. Thank you.
May it please the court? My name is Peggy Wilson. I represent Respondent Jason Wiske. Mr. Wiske also personally appears. And if allowed, we'd like to have Mr. Wiske also address the court. If you don't mind, I'd like to start with the releases. Justice Standridge, you're correct. My client is willing, ready, willing, and able to do whatever it takes to stay in practice and on probation. Generally, I've done this before where the releases only allow the respondent, the medical treaters indicate he is seeking treatment, he's been here this many times, and all is well. But as you see in the redactions that I did, I left a little part in there that says seeking treatment, he's come this many times, he and his wife, they're, period. And but we are very willing to reduce the release to only allow certain materials. But the probation monitor, John Mazurek, is very close to
Right.
Mr. Wiske, and they're
I read the
friends.
letter.
They meet weekly generally, and they meet monthly. So maybe if we reduce it to not the Office of Disciplinary or the Disciplinary Administrator's Office, we are fine with that, but
I was just asking the question. I'm not asking for any, I just asked the
Well,
question.
I appreciate it. I'd like to ask now, but it's probably a little beyond the time and the scope, but if, I don't mind reducing that at all. But we do believe the proposed probation plan meets the requirements of Rule 227. It is set that the misconduct can be corrected, has been corrected, and it's in the best interest of the public that Mr. Wiske stay in practice. It's true. What Ms. Walker said, totally true. He was very overwhelmed with illness. He had an overwhelming workload. He's out in the rural area. He practices criminal law, and at the time he was under contract with Crawford County for the children in need of care cases, which was just overwhelming him. And then being sick on top of that, you can only do so much, and he couldn't do it all. He has since cut down his caseload. Of course, he's withdrawn the contract with Crawford County for Children in Sync. He mainly works in criminal law, though. They've also implemented a new case management system that's very detail oriented, that provides his calendar, his due dates, that keeps him up to date. He works closely with his office manager and wife, who is involved in this. Mr. Mazurek has also has worked with them with a new computer. This new case, My Case software was to be implemented this month, but I think it's going to be February by the time it's all in. So they are working diligently to make sure his case management is organized and ready, and he can meet the deadlines. So his major health issues have been resolved. He still has some of them, but he's seeking treatment routinely. And the affidavit sets forth that he has been, and he's been complying with the probation plan prior to the 2 weeks that we submitted it prior to this hearing, which I believe is timely. But he also has the tools to know how to stop taking it all on, stop taking all the cases when a court says, I need to appoint you, to say, I can't do it. He has tools now to ask for continuances. He's ready, willing, and able to withdraw if he can't handle this, if he's got too many cases. And it ends up being, as you all may already know, practices mainly in criminal law, and a lot of his clients are indigents, and their court appointments. And he's got a lot now too. He's not overwhelmed. I don't want to ever say that, but he practices in Crawford County and out in the rural areas. And currently there's 4 attorneys taking felony appointments. So we have a lot of cases with fewer lawyers out in the rural areas. We know that's an issue. He's trying to take it all on. He also, in their practice, with his wife's help, a lot of his clients have drug issues. The criminal matters relate to drugs. But he's doing social work too by submitting, or I don't know, admitting his clients into treatment centers. It benefits his clients for the treatment. It benefits his clients for the sentencing and in front of the court. So he is also involved in a group or a planning committee to establish a drug court for the area, since it's so prevalent down there. So Mr. Wiske is a good lawyer, working hard, going to work with John Mazurek to make sure he stays level, stays stays able to continue his hard work. He even has, you may have noticed, a succession plan. Should something happen to him, he becomes disabled, he's unable or dies, Mr. Mazurek is the succession plan. So we asked too that Mr. Wiske be permitted to stay on probation and that the court adopt the probation plan. If there are no questions, Mr. Wiske would like to address the court.
Risk?
May it please the court, my name is Jason Wiske. In September of this year, I have been a practicing attorney for 27 years. I have been practicing in Pittsburgh, Kansas all the 27 years. Since opening my solo practice in May of 2004, my emphasis has been in regards to criminal law and child in need of care cases. Most of those clients are appointed by the district court. It's a rural area. There's not a lot of money down there. It's very rare that a client can manage to hire their own attorney. Today is one of the worst days of my career life. I have violated the rules of ethics in a number of ways, especially in regards to competence, diligence, expedient litigation. As the disciplinary attorney stated, this form of complaint is being dealt with in regards to 3 appeals of termination of parental rights. I'm especially ashamed of my representation of DT. I failed to file the appeal brief in the spring of 2022, which precluded any appellate review of the termination. In regards to BC, I did not diligently file the appeal or expedite litigation in regards to BC. The Court of Appeals did get a motion to appeal out of time, and it was heard on its merits, and the termination of parental rights was upheld.
I'm
In
sorry,
regard-
sir. I don't mean to interrupt. I'm confused. I have DT, AH, and AF.
Okay,
Who
I'm
is
sorry.
BC?
It's AH. The child's name was BC. I'm sorry.
Thank you.
In regards to AF, I waited too long in drafting the necessary documents. I did try to remedy this by getting her signature. I had extensive emails with her to try to get the signature. Was not able to get that by the time I withdrew from my contract with Crawford County. I accept full responsibility. While I may have been mistaken on bill timelines being stayed during COVID, having COVID-like symptoms, injury to my knee, and basically being overwhelmed for the vast majority of this time. These are explanations, they're not excuses. I am ashamed of my past conduct, but I don't want to dwell on this, and I want to move forward. The main thing in regards to being able to move forward is I did relinquish my sync contract. Just as a general explanation of that contract, there's one attorney hired by the county to be guardian ad litem and two attorneys hired by the county to represent parents in sync contracts. I think I saw maybe back in 2020 that Crawford County is like the third or fourth most heavy sync load. And when you think about Johnson County or Shawnee or Sedgwick County, that's telling a lot.
Is that per judge or period
Uh, Number of cases outstanding.
altogether?
Yes. A typical day and Monday, unless we had a special setting like a severance hearing, it would be an 8-page docket. We would have hearings scheduled 2 every 15 minutes. I am not involved in that area much anymore. I do have a few cases that the local judge asked me to take some cases due to conflicts and lack of counsel there, but it is much less. Additionally, in regards to the same contract, my wife and I were foster parents for more than 15 years, had more than 30 foster children. And besides being overwhelmed by the caseload, frankly, I became disillusioned with the state of child need of care cases, the system, if you want to go that far. I thought I was spinning the wheels and I wasn't getting anything done. Like I said, this is not an excuse, it's just an explanation. I am focused primarily in regards to current caseload, in regards to indigent criminal clients. I see my psychologist in regards to my mental issues, stress management, work life. I've been improving my calendaring and hope to get online additional computer programs to help me with that. Frankly, this is the first time in quite a while that I've actually enjoyed the practice of law on most days. I'm not dreading the state contract on Mondays, looking at my billing, and I'm a solo practitioner. I see what I've worked on, and my productivity has increased about 30% over the last 18 months. I'm trying to help my clients in new ways by getting them into treatment while their cases are proceeding. And not just waiting for a sentence where they're ordered to treatment, and by waiting that could cause them to fail. Getting good plea deals or charges dropped is a good legal outcome, but that does not permanently address most of my clients' needs in regards to drug and mental health issues. I would respectfully ask the court to approve the plan, and if there's any questions, I'd be happy to take them up.
Thank you. For your reserved 3 minutes.
May it please the court, unless there are any questions, I would waive rebuttal in this case.
No questions. Thank you.
Thank you.
Thank you to all of you for your arguments and comments today. The court will take this matter under advisement.